Further hearing in the interchange appeals.
Hoskins.
Good morning, my lords. We were on issue 2, the law of evidence in relation to Article 101.3. I had shown you what Mr. Justice Popplewell had said about the issue. I'd shown you what Mr. Justice Phillips said about the issue. And I turn to what the Court of Appeal said about the issue. So, Court of Appeal judgment, Core 2. If you could turn, please, to MS, page 5224.
Sorry, Mr. Hoskins, we're going to...
So, page 5224 in Core 2. It's the Court of Appeal judgment. And I'd like to pick it up at paragraph 78. One of the issues which arose before both the commercial court judges was the relationship of that standard of proof to the requirement of EU law, particularly in relation to the first condition, I mean the first of the 4 conditions in Article 101.3, that a claim that a restrictive agreement creates efficiencies must be founded on detailed, robust and compelling analysis, and that assumptions and deductions must be based on empirical data and facts, and not economic theory alone. As an analysis of how that requirement sits alongside the standard of proof under English law, so they identify this as a requirement of EU law, we adopt what Mr. Justice Phillips said at paragraph 24 of his second judgment, and I showed you that yesterday, in which Mr. Justice Phillips suggested that empirical data was required. You'll see that in the third line of the quote, and also that a robust analysis and cogent evidence will be required to establish on the balance of probabilities that 101.3 is satisfied, and you'll see that at the bottom of page 5224 and over to the top of the next page. Paragraph 80, they say that Mr. Justice Phillips, they agree with him that his analysis does not differ significantly from that of Mr. Justice Popplewell. You know that we disagree with that. But to the extent that there are any differences, we prefer the analysis of Mr. Justice Phillips. This is very important, the next bit, because it does crystallise their position. Insofar as Ms. Diana Rose QC, leading counsel for Visa, sought to argue that Mr. Justice Phillips adopted too prescriptive an approach and that any evidence should suffice, provided it meets the civil standard of proof, we do not accept that argument. So the Court of Appeal is rejecting the argument that any evidence should suffice, provided that it meets the civil standard of proof. In paragraph 85, secondly, the causal link between the restriction and the relevant benefits must be established by facts and evidence supported by empirical analysis and data, and not just economic theory. Paragraph 86. Thirdly, as paragraph 54 of the guidelines makes clear, the causal link must be sufficiently direct to be capable of proof, and an indirect effect will not generally be sufficient, precisely because cogent evidence of the link based on empirical analysis and data, and not merely economic theory, is required. So in our submission, you see the twin targets there. Must have empirical factual data, and that the normal balance of probabilities is to be attenuated by what's said to be the EU requirement for robust analysis and cogent evidence. Clearly, the contradistinction is intended to suggest that therefore something greater is required than a normal civil case. Now, whilst this is couched in relation to certain aspects of Article 101.3, the principles that certainly Mr. Justice Popplewell, Mr. Justice Phillips, they both approach this as a general issue about the approach to Article 101.3, and the Court of Appeal also is laying down principles that would be of general application to Article 101.3, and therefore these two legal issues are of general importance to the application of Article 1013 in all cases. This is a crucial and fundamental issue. The Court of Appeal then applied these findings to the particular facts of the case in a later part of the judgment. I'll take you to those in a minute, but in our submission it's quite clear that the Court of Appeal's findings on the law of evidence provided the fundamental bedrock of the analysis which followed, the application of Article 1013 in this particular case. And our submission is that if the Court of Appeal's findings on the law of evidence are wrong as a matter of law, then this part of its judgment, i.e. the application of 1013 to this case, cannot stand. So let's look at how these principles were applied by the Court of Appeal in the particular case. Still in the Court of Appeal judgment, obviously, page 5254. Beginning at paragraph 216, they are addressing Mr. Justice Popperwell's judgment. If I can pick it up between D and E, the Court of Appeal says, at places in this analysis, the judge, that's Mr. Justice Popperwell, did refer to the myth being causative of benefits, but this was very much on the basis of the economic analysis propounded by the experts. Then at paragraph 220, at the bottom, begins at the bottom of the page. At paragraph 339, Mr. Justice Popperwell identified the ways in which issuers potentially pass through the MIF to cardholders. Although at this stage he did not analyse the extent to which any of these could be said actually to incentivise card usage, a point which he dealt with at paragraph 403. At paragraph 400, he said that quantification of pass-through was difficult to estimate because MIF revenue was not an isolated pot of money. He noted that neither expert sought to quantify the extent of pass-through other than by adjectival terms. Very high, according to Dr. Niels, that's MasterCard's expert, and a significant proportion, according to Mr. Dryden, the AAM party's expert. Now, as we're going through this, bear in mind, of course, the obvious point that this is adversarial litigation, where one has a situation in which the experts are agreed or agreed to a certain extent on a point. A trial judge generally would not welcome parties seeking to spend a great deal of time on going through an issue which is in fact common ground. And that's an important contextual issue here. This is an adversarial procedure. If we can turn next to page 5257, paragraph 233. The judge, still dealing with Mr. Justice Popperwell, erred in his approach to pass-through because he ignored the need for cogent, factual evidence. So both of the targets are in play here, as to both the extent to which MIF income was passed through to cardholders and the extent to which such MIF revenue as was passed through did stimulate additional card usage by cardholders. There was no such evidence in this case. MasterCard could have produced evidence from issuers, but did not. In the circumstances, the judge should have concluded that MasterCard could not establish the necessary causal link between MIFs and net benefits. So in other words, although the experts had agreed that a significant proportion of the MIF was passed through to cardholders, according to the Court of Appeal, Mr. Justice Popperwell should have found that there was no causal link between MIFs and benefits because there was no empirical data, particularly from issuing banks, to confirm the experts' opinions. Go next, please, to page 5258, paragraph 242. Discussion and conclusions on the AAM party's appeal. The Court of Appeal says, despite the obvious care and detail devoted by the judge to the Article 1013 issue, there are a number of flaws in Mr. Justice Popperwell's approach. First, in considering the first critical stage in the causation analysis, which we identified at paragraph 88 above, namely whether the issuers were incentivized to increase card usage to a greater extent than they would have been anyway, the judge has noted towards the end of his analysis at paragraph 408 the absence of any factual evidence from the issuers, but he paid insufficient regard to that absence of evidence. And then crucially, this may have been because it was accepted by Mr. Dryden that there would have been some pass-through of MIF income, a matter to which we return below. So again, you'll see the Court of Appeal devaluing expert evidence where there is no, as the Court of Appeal sees it, corroborating factual evidence from issuers. And of course, expert reports, as you'll be aware, we're not going to trawl through the detail here, but experts based their opinion on the economics in a particular case on the factual evidence in the case. It's not the case here that you simply had experts on all sides propounding theories without any reference to factual evidence. And I will come to show you the particular, some of the particular factual evidence that the experts did rely upon. We're not here in a vacuum of factual evidence. Paragraph 245 at MS page 5259. Secondly, the judge hardly addressed the second critical stage of the causation analysis identified at 88 above, namely the extent to which card usage actually increased as a consequence of the steps taken by the issuers to incentivize it. The judge mentioned this point in passing at paragraph 403, and as we have said, recognized that it was sound in principle. To be fair, the experts agreed, at least as regards credit cards, that pass-through would incentivize card use. There was, however, no empirical factual evidence on this point, which seems to have been based on economic theory. You have the point, you see the theme. Despite the fact that the experts have agreed something, the Court of Appeal says it is not to be given weight if there is no empirical factual evidence on the point. Paragraph 249 over the page at MS page 5260. Although the judge said at paragraph 312 that the increase in card usage and so on the benefits enjoyed by merchants from the charging of MIFs was made good on the evidence before him, so that was Mr. Justice Popplewell's finding on the evidence he had, it is entirely unclear to what evidence he was referring, let alone whether it was the cogent, factual and empirical evidence which European law requires. So this is a requirement of European law according to the Court of Appeal. Paragraph 252, MS, page 5261. The fourth flaw in Mr. Justice Popplewell's analysis is related to the criticism of his failure to carry out the balancing exercise required under Article 1013 because he rejected the always cards point. This concerns his treatment of pass-through. Mr. Hoskins can legitimately point out that in the trial before Mr. Justice Popplewell, unlike in the trial before Mr. Justice Phillips, it was not being contended by the AAM parties that the scheme had failed to establish pass-through at all. As the judge recorded at paragraph 400, Mr. Dryden accepted that a significant proportion of MIF income was passed through to cardholders. His point and the AAM party's case was that in the circumstances where it was not 100%, and MasterCard could not establish by evidence the extent of pass-through for the purposes of the first and second critical steps, the extent to which MIF revenue was used to incentivize card usage and did in fact stimulate additional card usage could not be established. So the Court of Appeal's analysis of Article 1013 is based on its finding that as a matter of EU law, empirical factual data is required to make good issues under Article 1013, and that the standard to be applied is robust and cogent evidence, which is clearly intended to indicate a heightened application of the civil standard. And those are the two errors of law that we bring before this House. Let's turn then to the relevant law on evidence. I'd like to begin with Council Regulation 1 of 2003. You find that in Primary Authorities 1 at tab 16. That's MS page 447. Primary Authorities 1, tab 16. MS page 447. Council Regulation 1 of 2003 is the bedrock of the application of Articles 101.1 and 101.2. It deals with a number of matters, and you'll see from the heading the Council Regulation is entitled On the Implementation of the Rules on Competition laid down in Articles 81 and 82 of the Treaty. I'd like first of all to look at Recital 5 at the top of MS 448. In order to ensure an effective enforcement of the community competition rules, and at the same time the respect of the fundamental rights of the defence, this regulation should regulate the burden of proof under Articles 81 and 82 of the Treaty. It should be for the party alleging an infringement of Article 81.1 and 81.2 to prove the existence thereof to the requisite legal standard. It should be for the undertaking invoking the benefit of a defence against a finding of an infringement to demonstrate the required legal standard that the conditions for applying such defence are satisfied. And those issues are not in dispute. The burden is on the retailers to establish a breach of Article 101.1. The burden is on the schemes to establish compliance with Article 101.3. But Recital 5 goes on to say, this regulation affects neither national rules on the standard of proof, nor obligations of competition authorities and courts of the member states to ascertain the relevant facts of a case, provided that such rules and obligations are compatible with general principles of community law. So in other words, what Recital 5 is telling us is that the standard of proof is governed by national rules, provided that such rules are compatible with general principles of community law. And those general principles include principle of subsidiarity and the principle of procedural autonomy. Procedural autonomy being the fact that where a particular issue is not regulated by EU law, it is governed by national law, subject to the principles of effectiveness and equivalence. And I refer to subsidiarity because one of the arguments that's put against us is that there must be consistency of application in relation to Article 101.3. Now, clearly, consistency of application is desirable as a matter of EU law, but the very fact that the principle of subsidiarity is a general principle of EU law tells you quite clearly that absolute consistency is not required in all aspects. That's what subsidiarity is about. EU law permits differences in certain areas. And what Recital 5 tells us is that in relation to the standard of proof, differences are permitted. So the argument that 101.3 requires consistency of application, therefore the standard of proof must be the same, is clearly incorrect in our submission for those reasons. And then in terms of the substantive content of the regulation, if you could look please at Article 2, page 454, you see that Article 2 regulates the burden of proof, but says nothing about the standard of proof. It's silent, simply silent on the standard of proof. And that's because, as a matter of subsidiarity, standard of proof is left to the national legal systems by the regulation. Now, the position set out in the regulation, in particular in Recital 5, has been subsequently confirmed by a judgment of the Court of Justice. It's case C74 of 14 Ituras. It's in Primary Authorities Bundle 2, tab 18. And if you could pick it up, please, at MS, page 561. This was a preliminary reference. In our submission, nothing hinges on that because I'll show you the principles in relation to the law of evidence that the Court of Justice set out. Paragraphs 29 to 32. In the first place, inasmuch as the referring court raises the issue whether the dispatch of a message, such as that at issue in the main proceedings, may constitute sufficient evidence to establish that operators which used the system were aware or ought to have been aware of the content of that message. So the question was whether a message that had been sent actually fixed the recipients with knowledge or not. That was the factual question, a question of knowledge. It must be noted that in accordance with Article 2 of Regulation 1 of 2003, in any national proceedings for the application of Article 101, the burden of proving an infringement is to rest on the party alleging the infringement. Although Article 2 of the regulation expressly governs the allocation of the burden of proof, that regulation does not contain any provisions on more specific procedural aspects. Thus, in particular, that regulation does not contain any provision in relation to the principles governing the assessment of evidence and the standard of proof in national proceedings. 31. That conclusion is confirmed by Recital 5 of Regulation 1, 2003, which expressly states that the regulation does not affect national rules on the standard of proof. According to settled case law, in the absence of EU rules on the matter, it is for the national legal order of each member state to establish them in accordance with the principle of procedural autonomy, and that is obviously subject to the principles of equivalence and effectiveness. So the Court of Justice agrees, and it's the Court of Justice that matters, that the law is as set out in Recital 5. And paragraph 34, dealing with the facts of the particular case, in contrast to that presumption, the answer to the question whether the mere dispatch of a message, such as that at issue in the main proceedings, may, having regard to all of the circumstances before the referring court, constitute sufficient evidence to establish that its addressees were aware or ought to have been aware of its content. So the issue is, does the mere dispatch of a message fix the recipient necessarily with awareness of it? And the answer is that question must be regarded as relating to the assessment of evidence and to the standard of proof, with the result that it is governed in accordance with the principle of procedural autonomy and subject to the principles of equivalence and effectiveness by national law. That's the EU law position on the standard of proof to be applied to Article 1013. EU law says that it is a question for the national law. You already see one of the defects in the Court of Appeal's approach, which is to assume that the application of the standard of proof in relation to Article 1013 is a matter of EU law that requires certain standards to be applied. If I can turn next then to English law. In our submission, it's well established in English law that there is only one civil standard of proof, and that is the balance of probabilities.
I wonder if it's really talking about, if this is really about standard of proof. One gets the impression the Court of Appeal is more concerned about the type of evidence relied on. They're saying they want analysis of empirical data rather than purely theoretical arguments.
Well, I think you're right to make that nuance. The Court of Appeal introduced, as I showed you in the passage, this is a standard of proof point, but I've identified two targets. Now, the second one, the type of evidence, is arguably distinct from a pure question of standard of proof, though clearly they're interlinked. With the question of what sort of evidence you need to produce to meet the standard, there is a linkage. But I understand and I accept the distinction you're making.
When they do refer to dicta, referring to the need for evidence to be cogent or convincing, and no doubt you're going to come to those.
Yes. That's where I'm headed.
Yes.
But that's the second point I wanted to pick up.
But that's a slightly different point.
Agree. And the second point, the robust and cogent evidence point in our submission is a standard of proof point.
Yeah.
because the Court of Appeal says that that approach, the need to add those words, robust and cogent, to the civil standard is because of the inherent implausibility of an Article 1013 defence. So, well, I absolutely agree. There is what I would say is a pure standard of proof point, which is there a standard of robust and cogent evidence to be applied when applying the balance of probabilities? And there is a second, not necessarily pure standard of proof point, but related point, which is, must you have empirical data for all or any aspect of Article 1013? So turning to English law, one civil standard of proof, the balance of probabilities, and secondly, the inherent probability or improbability of an event is a matter to be taken into account when weighing the probabilities and deciding whether, on the balance of probabilities, the event occurred. But that does not alter the position that there is only one standard, the balance of probabilities. It's the lion or the Alsatian in Regent's Park point.
I should just say, I don't know if this point goes anywhere, but in Eturas, the court does also point out in paragraph 35 that the national rules governing the assessment of evidence and the standard of proof mustn't render the implementation of EU competition rules impossible or excessively difficult, and in particular must not jeopardise the effective application of Article 101.
That's correct. And 101, of course, includes both elements of 101, 101.1 and 101.3. And it's a point you see particularly, I think, in Visa's written submissions, that one has to bear in mind precisely that point. And it's a point I'm going to come on to when I show you what the Commission's practice has been in relation to Article 101.3, because the Commission has recognised the difficulty, the impossibility, if one applies too high a standard to MIFs. And I'll show you the approach that the Commission has therefore taken. So yes, my Lord, we say that is a relevant aspect of this discussion. There's obviously a number of authorities that deal with these points, and they're well known in the House of Lords. I think we can probably simply go to Re B, which is one of the well-known ones. That's in Authority 6, tab 50, page MS 2781. It begins at 2773. It's a well-known case, and the facts don't really matter for this purpose. So I'll go straight to paragraph 11, please, in the well-known speech of Lord Hoffman. It was this notion of having regard to inherent probabilities which Lord Nichols attempted to capture in Re H. And he quotes from Lord Nichols. The balance of probability standard means that the court is satisfied an event occurred if the court considers that on the evidence the occurrence of the event was more likely than not. When assessing the probabilities, the court will have in mind as a factor, to whatever extent is appropriate in the particular case. So this cannot be a sort of general approach. It has to be appropriate in the particular case, that the more serious the allegation, the less likely it is that the event occurred, and hence the stronger should be the evidence before the court concludes that the allegation is established on the balance of probability. And then some examples. Fraud is usually less likely than negligence. Deliberate physical injury is usually less likely than accidental physical injury. A stepfather is usually less likely to have repeatedly raped and had non-consensual oral sex with his underage stepdaughter than on some occasion to have lost his temper and slapped her. Built into the preponderance of probability standard is a generous degree of flexibility in respect of the seriousness of the allegation. Although the result is much the same, this does not mean that where a serious allegation is an issue, the standard of proof required is higher. It means only that the inherent probability or improbability of an event is itself a matter to be taken into account when weighing the probabilities and deciding whether on balance the event occurred. The more improbable the event, the stronger must be the evidence that it did occur before. On the balance of probability, its occurrence will be established. And then paragraphs 13 to 15. My lords, I would invite your lordships fully to approve these observations. I think that the time has come to say once and for all that there is only one civil standard of proof, and that is proof that the fact in issue more probably occurred than not. Then over the page at 14, finally I should say something about the notion of inherent probabilities. Lord Nichols said in the passage I've already quoted that, and then you see the passage repeated. And then at 15, I wish to lay some stress upon the words I've italicized, i.e. to whatever extent is appropriate in the particular case. Lord Nichols was not laying down any rule of law. There is only one rule of law, namely that the occurrence of the fact in issue, I stress the fact in issue, must be proved to have been more probable than not. Common sense, not law, requires that in deciding this question, regard should be had to whatever extent appropriate to inherent probabilities. So one is looking at a particular fact, and one is asking in relation to that particular fact to what extent appropriate it is appropriate to have regard to inherent probabilities. So it's looking at facts, and it's tailored to particular facts. It cannot be a general approach.
I mean, this is looking at things that have in fact happened.
Yes.
How does that read across to what we're dealing about, which is the counterfactual of what would have happened in certain eventualities?
Well, here in 101.3, we're assuming that we only get to this question if the schemes have lost in relation to 101.1. Then in relation to 101.3, you have the 4 criteria, and there you're not necessarily in a counterfactual world, because there is a scheme in operation for MasterCard and Visa. It has been in operation for a large number of years. So the evidence is historic in the sense that you can come and say, we satisfy the 4 conditions of 101.3 because of the following, and refer to historical facts.
So the context here is the probability or improbability of the pass-through of the benefits to the consumer.
That's one of the issues I'm going to come to. And I'm going to make submissions on that, whether that is improbable.
But you say that's nothing to do with counterfactual.
No, it doesn't have to.
Did the scheme operate that way?
That's right, yes.
Well, it's not simply pass-through, because one of the points the Court of Appeal make is that you have to compare the degree of incentivization in the presence of the myth arrangements with what would otherwise.
I agree. One of the points I'm going to make to you is when you're looking at Article 101.3 in this case, or indeed in any case, there are a myriad of issues that arise. It's a multifaceted approach. And so those are the 2 well-established principles of English law. And in addition, subject to the need to obtain permission from the court to adduce expert evidence, expert evidence is not excluded from consideration in English law as a matter of principle. Its ability to adduce it must be justified, and the court must say, yes, it's justified in this case. But as a matter of principle, reliance upon reference to expert evidence, expert economic evidence, is not excluded. And in our submission, the approach of the Court of Appeal was not consistent with those principles for the following reasons. First of all, the finding that compliance with Article 101.3 required empirical data is not consistent with the principle that a party may seek to prove its case by reference to the evidence that it sees fit. The English law of evidence does not exclude certain categories of evidence from being potentially relevant, nor does it dictate that certain issues may only be proved on the basis of certain categories of evidence. The basic evidential principle in English law is that the judge is entitled to consider all relevant evidence in the round. Secondly, there is only one civil standard of proof, the balance of probabilities. As a matter of law, we say it wasn't open to the Court of Appeal to find that for the application of Article 101.3, the balance of probabilities could only be met by robust analysis and cogent evidence. First of all, it's not permissible to seek to add to, alter, or to gloss the only civil standard of proof, that is the balance of probabilities. There is only one test. And the third point is that one cannot justify the Court of Appeal's finding that the application of Article 1013 requires robust analysis and cogent evidence, which is clearly intended to be some form of greater scrutiny than a normal civil case. You cannot justify that in reliance on the principle that the inherent improbability of an event is a matter to be taken into account when applying the civil standard of proof. And we say that for two reasons. First of all, the sorts of issues raised by Article 1013 are far removed from the examples given by Lord Nichols in Re H. It's also far removed from the example of rectification, which you'll have seen in Sainsbury's written case. In all cases, I think it's safe to say, the application of Article 1013 raises multifaceted, factual, and economic issues. And the nature of those issues will differ from case to case. The application of Article 1013 is not a straightforward factual issue, such as, did A deliberately lie to B? Did this father abuse his own child? They are qualitatively, materially different types of issue. And therefore it cannot be said that the fulfillment of Article 1013 is inherently improbable in the same way as the types of examples one sees in case law. The second point is that it would be wrong to adopt a monolithic approach to Article 1013. Its application in any particular case will raise a number of different issues. And it cannot simply be assumed that establishing every one of those issues is inherently improbable. You might have a large number of Alsatians walking through Regent's Park. You might have, unlikely though it may seem, some Alsatians and some lions. But what you cannot assume is that you have a great herd of lions roaming through Regent's Park. And take the example of issue or pass on that was put to me. Let's ask the question, is it inherently improbable that issuers will use income from the MIF to encourage card use? For example, by offering rewards to cardholders, or not charging a fee to issue and allow them to hold cards. One only has to ask the question to see, of course it isn't inherently improbable. I'm not asking this court to make a finding on the degree of probability. I'm just making the point. It's not so obviously inherently improbable that you leap into the Re-B type situations. And it follows that that attempt to justify the Court of Appeal's approach by saying you must assume it's inherently improbable that Article 1013 will apply in any case, or in this case indeed, is simply misplaced. Now, since the approach in our submission of the Court of Appeal is inconsistent with English law, let me come back to this question of whether EU law imposes specific requirements on the application of Article 1013, which must be applied in spite of the generally applicable English principles, English law of civil evidence. Is there something in EU law that we haven't seen yet that means that the approach of the Court of Appeal was correct? Our submission is that EU law does not require any alteration to the generally applicable English law principles of civil evidence. Let me deal first of all with, and I will split them up in the way my Lord Reid split up the issues. I'm going to deal first of all with the pure standard of proof point. First of all, in relation to standard of proof, you have Recital 5 of Regulation 1/2003, and you have the Aturis judgment. which, as I've shown you, establish that in the absence of EU rules governing the standard of proof under Article 1011, the standard of proof is governed by national law. That's what EU law says. And as I've submitted, whilst it's clearly desirable that there should be consistency in the application of Article 101 across the member states, EU law does not require perfect consistency in all cases. If it did require perfect consistency in relation to standard of proof, it would have regulated the standard of proof in Regulation 1 of 2003. But instead, the Community Legislature chose to adopt an approach of subsidiarity, leave it to national law, and that necessarily, therefore, involves the possibility of an inconsistency of approach. That's what EU law says. The second point is that the case law relied upon by the retailers on this issue does not detract from this clear position. Can we go first of all to case T16801 at GlaxoSmithKline against the Commission? You find that in Primary Authorities 2, tab 19, and I'd like to pick it up at page 630. Again, we don't need to go into the details. It was a cartel case. It involved pharmaceuticals. There was a finding of infringement, and it was appealed by GlaxoSmithKline to the General Court. Paragraph 235. Consequently, a person who relies on Article 81 sub 3 EC must demonstrate that those conditions are satisfied by means of convincing arguments and evidence, in reference to previous cases. So you'll see where this language of convincing arguments and evidence comes from. And then at page 643, paragraph 280, this is dealing with an Article 1013 argument, the final sentence, in accordance with the case law cited at paragraphs 247 and 248 above. Any advantage in the form of a gain in efficiency, that's the first condition of Article 1013, must therefore be taken into account, provided that it is objective and appreciable, and that its existence is provided convincingly.
It is proved.
I'm sorry, no, I didn't.
It's proved convincingly.
It's proved, I'm sorry. Proved convincingly. Now, those phrases, convincing arguments and evidence, and must be proved convincingly, are submitted by the retailers to show that there is an EU law standard of proof in relation to 1013, convincing arguments and evidence. Now, that statement, the reference to convincing arguments and evidence that one sees in paragraph 235 of GlaxoSmithKline, was repeated in the case T11108, that's the MasterCard and Commission first instance case, at paragraph 196. It simply sets out the same wording, so I don't intend to take you to it, but for your note, it's Primary Authorities 2, tab 24, MS, page 959. It simply repeats, a person who relies on Article 81.3 must demonstrate that those conditions are satisfied by means of convincing arguments and evidence. And our submission is that those cases, those few words in those cases, do not detract from the clear statement in Recital 5 of Regulation 1 of 2003 and the Aturis judgment that when a national court or competition authority is applying Article 1013, the standard of proof is governed by national law, not EU law. And I insist on the point when 1013 is being applied by a national court or authority. Because both GSK and the MasterCard case judgments concern the consideration of Article 1013 by the Commission. EU law does not recognise and apply a balance of probability standard. Not surprisingly, because the common law is in the minority in the EU. What the EU courts have said is we require convincing, quote unquote, convincing arguments and evidence. But it cannot be taken from that that means that consideration, there's been a juxtaposition of what is required under the balance of probabilities in the EU law, and the EU courts are saying, and the EU standard is higher. They're simply saying what their standard is. And the words convincing arguments and evidence don't really tell you anything about whether that is higher, lower, the same as balance of probabilities. There's no magic in those words. So when Article 1013 is applied by an EU institution, the standard of proof is convincing arguments and evidence. But as we know from Regulation 1 of 2003 and de Touris, when Article 1013 is applied by a national body, the standard of proof is governed by national law. We're told the answer. You don't look to EU law at all, whatever the words convincing arguments and evidence means. That's standard of proof. So let me turn now to EU law on the nature of relevant evidence. What evidence, what types of evidence can you rely upon to seek to make good reliance on Article 1013? There is a sort of logic point here. It's not a pure logic point, but if you're with me, that EU law leaves the standard of proof to national law, then it would be, let me say, odd, illogical, for the nature of the evidence required to meet that standard to be governed by EU law. It'd be an odd position if they were split in that way, those two clearly interlinked issues. But there's a stronger case in relation to that. It's quite clear from the case law that there is no difference between EU and English law as to the nature of evidence which may be considered under Article 1013. And that's because EU law also applies the principle of, quote unquote, the unfettered evaluation of evidence. And one sees that in a case C 411-04E, Salzgitter Mannesmann, Court of Justice Authority. It's an Additional Authorities Bundle 10, tab 81. I'm going to pick it up at MS 4073. So, judgment of the Court of Justice. You'll see opposite H3, the Commission investigated a number of undertakings producing seamless steel tubes under Article 81 EC, so this is a competition case. And then at the bottom of the page, in the light of the evidence acquired, including a document passed to the Commission called the sharing key document by a third party not involved in the proceedings, and not disclosed to the undertakings under investigation, the Commission adopted the decision in which it found that the 8 undertakings to which the decision was addressed had concluded an agreement. So a document relied upon, not disclosed to the undertakings under investigation, relied upon in the decision. And then a few lines down, under the terms of that agreement, each undertaking was prohibited from selling the steel tubes which were the subject of the investigation on the domestic market of another party to the agreement. And then again in the middle of the page, just before the held, M appealed seeking further relief. And one of the arguments was it considered that the procedure leading to the contested decision infringed its right to a fair legal process. If you can turn then to page 4085. Paragraphs 44 and 45. The court says, in those conditions specific to the Commission's investigations into anti-competitive practices, the principle that everyone has the right to a fair legal process cannot be interpreted as meaning that documents containing incriminating evidence must automatically be excluded as evidence, i.e. that the Commission can't rely upon them, when certain information must remain confidential. That confidentiality may also relate to the identity of the authors of the documents and also to persons who transmitted them to the Commission. In light of the foregoing considerations, the Court of First Instance was correct to hold, as regards the admissibility of the sharing key document as evidence of the infringement referred to in the contested decision, that the principle that prevails in community law is that of the unfettered evaluation of evidence, and that it is only the reliability of the evidence that is decisive when it comes to its evaluation. A very clear statement of the principle of unfettered evaluation of evidence by the Court of Justice. So I need to take you back to GlaxoSmithKline to deal with the secondary issue, which is the nature of evidence point. Primary Authorities 2, tab 19, page 566. I'd like to pick it up at page 633. And our submission is that the judgment in GlaxoSmithKline is consistent with the principle of the unfettered evaluation of evidence. As I'll show you, what this judgment establishes is that the Commission must examine any factual evidence submitted by an undertaking seeking to rely on Article 1013. What GlaxoSmithKline does not establish is that factual evidence is necessary to establish all or any aspect of Article 1013, which is what is said by the retailers. If we can pick it up, please, at paragraph 247. You see the heading, Evidence of a Gain in Efficiency. In order to be capable of being exempted under Article 81(3)(EC, an agreement must contribute to improving the production and distribution of goods. So that's the first condition, the first criteria of 1013. 248. It is therefore for the Commission in the first place to examine whether the factual arguments and the evidence submitted to it show in a convincing manner that the agreement in question must enable appreciable objective advantages to be obtained. And then at 249, that approach may entail a prospective analysis, in which case it is appropriate to ascertain whether, in the light of the factual arguments and the evidence provided, it seems more likely either that the agreement in question must make it possible to obtain appreciable advantages, or that it will not. So it can be, to pick up Lord Sale's question of earlier, it can be you are in a situation sometimes where you're looking prospectively and looking at facts, but that's not always the case. And then paragraph 304 at MS 649, the balancing exercise. After concluding its examination of the factual arguments and the evidence submitted by GSK, and finding that they did not demonstrate the existence of an appreciable objective advantage, the Commission did not carry out the complex assessment which would have been involved by the exercise seeking to balance that advantage against the disadvantage for competition identified in the part of the decision devoted to the application of Article 81(1)(EC). And then at 307, consequently, the Commission's conclusion that there is no need to carry out a balancing exercise, which would show in any event the advantage associated with Clause 4 does not offset the disadvantage which it represents for competition, cannot be upheld. The Commission was required first to conduct an appropriate examination of GSK's factual arguments and evidence in order to be in a position to carry out, secondly, the complex assessment necessary in order to weigh up the disadvantage and the advantage associated with the clause. So the retailers rely on that to say that this case, the General Court, says that you must have factual evidence in Article 1013 cases. Our submission is that's clearly not the case. It's not saying you must have factual evidence. It's saying that when an undertaking chooses to put forward factual evidence, the Commission must examine it, and no more and no less. Can I turn next to the Commission's exemption guidelines? The Court of Appeal also relied upon these guidelines to justify its finding that empirical analysis and data is required to fulfill Article 1013. I'll show you first of all where the Court of Appeal says that. So, Court of Appeal judgment, Core 2, MS 5226. It's paragraph 86. Thirdly, as paragraph 54 of the guidelines makes clear, the causal link must be sufficiently direct to be capable of proof, and an indirect effect will not generally be sufficient, precisely because cogent evidence of the link based on empirical analysis and data, and not merely economic theory, is required. So let's turn to the Commission guidelines. You find those in Primary Authorities, Bundle 3, Tab 30, and they begin at MS 1616. I'd like to pick it up, please, at page 1623. You'll see the heading in the second column, first condition of Article 81.3, efficiency gains. Paragraph 50, the final sentence of paragraph 50. Given that for Article 81.3 to apply, the pro-competitive effects flowing from the agreement must outweigh anti-competitive effects, it is necessary to verify what is the link between the agreement and the claimed efficiencies, and what is the value of these efficiencies. And at paragraph 51, all efficiency claims must therefore be substantiated so that the following can be verified: the nature of the claimed efficiencies, the link between the agreement and efficiencies, the likelihood and magnitude of each claimed efficiency, and how and when each claimed efficiency could be achieved. Then at paragraph 53, letter B, i.e. the link, allows the decision maker to verify whether there is a sufficient causal link between the restrictive agreement and the claimed efficiencies. Paragraph 54, the one referred to by the Court of Appeal, the causal link between the agreement and the claimed efficiencies must normally also be direct. Claims based on indirect effects are, as a general rule, too uncertain and too remote to be taken into account. Then it gives an example of when a direct causal link exists. Then it gives an example of indirect effect. You will note that the paragraph does not say anything about the nature of the evidence required to establish a direct link. Paragraph 56. In the case of claimed cost efficiencies, the undertakings invoking the benefit of Article 81.3 must, as accurately as reasonably possible, calculate or estimate the value of the efficiencies and describe in detail how the amount has been computed. They must also describe the methods by which the efficiencies have been or will be achieved. The data submitted must be verifiable so that it can be a sufficient degree of certainty that the efficiencies have materialized or are likely to materialize. So even on the guidelines, it's not an exercise of perfection. It's as far as reasonably possible, and it's a sufficient degree of certainty. But it's important not to read, as Ms. Rose submitted correctly, these guidelines as some sort of detailed statutory framework. And one sees that very clearly if I can ask you to turn to page 1616 in the introductory paragraphs to the guidelines. Paragraph 4. The present guidelines set out the Commission's interpretation of the conditions for exception contained in Article 81.3. It therefore provides guidance on how it, i.e. the Commission, will apply Article 81 in individual cases. Although not binding on them, these guidelines also intend to give guidance to the courts and authorities of the member states. So, guidance, not binding rules. Paragraph 6. The standards set forth in the present guidelines must be applied in the light of the circumstances specific to each case, this excludes a mechanical application. Each case must be assessed on its own facts, and the guidelines must be applied reasonably and flexibly. Paragraph 7, I pick it up about halfway down. The Commission's position, however, is without prejudice to the case law of the Court of Justice and the Court of First Instance concerning the interpretation of Article 81, 1 and 3, and to the interpretation of the community courts may give to those provisions in the future. And therefore it's quite clear and clearly legally correct that the guidelines cannot trump the unfettered evaluation of evidence principle established and recognised by the Court of Justice, for example, in the Salzgitter case. The guidelines cannot undermine the unfettered evaluation of evidence. And therefore, the guidelines cannot provide a legal justification for requiring empirical analysis and data in respect of each or any aspect of Article 1013. The Court of Appeal also relied on the Commission decision in the earlier MasterCard case for its approach to the law of evidence. I can deal with that now. I don't need you to turn up the decision, I'll just simply give you the reference that paragraph 85 of the Court of Appeal's judgment referred to recitals 689 to 690 and 695 of the Commission decision. And the reference to paragraph 85 of the Court of Appeal's judgment is Core 2 MS, page 5225. And I'll come to look at those particular recitals. But two important points to make at the outset. First of all, before the Commission, MasterCard did not put forward any empirical data in support of its Article 1013 arguments, and the decision must be read in that context. As I'll show you later, before Mr. Justice Popplewell, MasterCard relied on detailed data produced by the Commission, amongst other sources, to support its Article 1013 cases. But there is that sharp distinction between these claims and the Commission decision. And secondly, the Commission's MasterCard decision was adopted in December 2007. And as, again, I will show you, the Commission's practice in relation to the application of Article 1013 to MIFs has developed materially since that decision. Again, I'll show you the detail of that. But in relation to this particular issue of the lack of any empirical evidence, the fact that MasterCard didn't produce empirical evidence before the Commission, if we can go to the decision, that's Appendix 1D, and it's MS 7083.
Sorry, is it page?
So 7083. Recital 689, as set out in the Statement of Objections to MasterCard, it cannot just be assumed, as MasterCard does, without detailed economic and empirical analysis, that a MIF maximizes the overall benefits of a system to merchants and cardholders. So you'll see there the Commission registering the fact that MasterCard had not produced detailed economic and empirical analysis and instead proceeded on assumption, i.e. it was a pure case of economic theory. Recital 690. Ms. Rose has asked me to point out footnote 836. MasterCard's general references to economic theory in its submissions do not go beyond paraphrasing, partly inaccurately, some general conclusions that might be drawn from economic models, but do not specify the models used, the assumptions relied on, and the facts and data that support the analysis. Recital 690 I'm going to pick it up 1, 2, 3, 4, 5, 6 lines down at the end of the 6th line. Apart from MasterCard's general assertion that balancing of the demand of cardholders and merchants leads to a better performance of the MasterCard system, is inherent and indispensable to the operation of a four-party payment card system, contributes to overall economic welfare, and therefore undoubtedly fulfills the first condition of Article 81.3 of the treaty, no such analysis and empirical evidence was provided to the Commission. And then page 7093, recital 732. On the previous page, you'll see the heading Conclusion on the First Condition of Article 81.3 of the Treaty. And then in 732, any claim that a MIF creates efficiencies with the meaning of Article 81.3 must therefore be founded on a detailed, robust, and compelling analysis that relies on its assumptions and deductions on empirical data and facts. MasterCard has not provided such analysis and empirical evidence, only a general assertion.
What do you say about the first sentence of that paragraph?
Well, I'd say two things. First of all, it must be viewed in the context of a case in which MasterCard has simply relied on general assertion. And I say that the Commission's statement in this decision must be read subject to the regulation, must be read subject to the Court's case law. Because insofar as the Court has stressed the unfettered evaluation, that cannot be trumped by a Commission decision. And the reason why the regulation is relevant is that this is an application of Article 101.3 by the Commission. Therefore, the Commission is applying the EU law of evidence, whereas it's quite clear from Recital 5 and the Aturis case that when a national court is applying Article 101.3, it must apply the national standards.
So the first sentence is not applicable to an analysis by a national competition authority.
It's certainly not binding on it, my lord. We're in a similar sort of status that we had with Ms. Rose's submissions on restriction. Of course, what is you see in a Commission decision is relevant to an English court. It may be persuasive. That's the way that Lord Hoffman put it in Korean. The point is it's not binding. And you see, I'm sorry.
Well, I was just going to say, sometimes in English law, where evidence is available to a party, but it chooses not to call it, inferences may be drawn against that party on the facts. Yes. Now, you've emphasised that this is a case where things did happen in the past because the scheme has been running for a long time. Might it be said that MasterCard's failure to call empirical evidence about what actually happened under the scheme, which was available to it, could ground inferences about what did in fact happen under the scheme?
2 points in relation to that. My recollection is that that was a point that was run, attempts to be run, or was run by AAM before Mr. Justice Popplewell, saying that because you hadn't produced certain types of evidence, the inference must be drawn, and that wasn't accepted by Mr. Justice Popplewell. And the second point is that wouldn't affect the legal errors of the Court of Appeal, because the question of a failure to produce evidence and an inference to be drawn would then feed into whether the balance of probabilities were met. It wouldn't alter the two legal points that the Court of Appeal relied upon. It might be a separate and independent reason why we would be criticised, but it's not the basis the Court of Appeal relied upon, and it's not actually relevant to those two legal issues. It would feed into an assessment of all the evidence in the round.
And can I just, to clarify my own mind, be clear why we're debating this? Because the 101.3 issue is going back to the Competition Appeal Tribunal. So are you basically seeking guidance from us as to how the Competition Appeal Tribunal should approach?
Absolutely. If this does go back, because obviously if we win on the first issue, these cases finish.
Yep.
If this does go back, it's very important that it goes back to the Competition Appeal Tribunal on the right legal basis. So first of all, one needs to have a clear statement from this court as to what the law of evidence is in relation to Article 101.3. And secondly, I make the point that the whole of this part of the Court of Appeal's judgment is so infected by those two errors that it all should fall, because we don't want to find ourselves in a position where even if we've won on this point, we're back in the Competition Appeal Tribunal, and you've got the retailer saying, yes, but look at this paragraph where the Court of Appeal said something specific about issue or pass on or always cards. Our point is that none of this can survive because the whole analysis is based on those two basic principles which we say are flawed.
Yes, thank you.
Now, the Court of Appeal also relied on paragraph 695, so we should perhaps look at that. It rather looks as though the argument in this paragraph is that the nature of a balancing exercise required under 81.3 necessitates an ability to quantify the restrictive effects on the one hand and the efficiencies generated on the other, so that you can balance the one against the other.
2 points in relation to that, my lord. You have it's the same sort of point you put to me before, which is, if insofar as this can be read as the Commission saying you must have empirical evidence, you have my submission on that. And the second point is I'm going to turn very shortly to the Commission's practice and show you that certainly in its practice, the Commission has not required empirical evidence on every aspect of Article 1013 in relation to MIFs.
Because the point being made here might not simply be a point about the law of evidence, as it were, but it might be a conclusion drawn from Article 81.3 itself.
Sorry, that empirical evidence is required.
Yes, that 81.3 requires a balancing. The nature of balancing requires an ability to quantify the countervailing considerations, and you can't quantify on the basis of a purely without having some empirical data.
Well, the submission on that is it's clear from the guidelines themselves that it's not, as I submitted to you, an exercise in perfection. This is not a ledger exercise where one looks at cost on one side and benefits on the other. Indeed, if one is looking at balancing the restriction on competition, it's very hard to see how one would achieve to put a figure on that as a value. If you're looking at the benefits and seeking to put a value on those and balancing them with the restrictive effect on competition, you don't find in Commission decisions them trying to put an overall evaluation because it would be impossible in most cases.
Right.
So that it's simply not a ledger exercise.
So what do you say then about the last two sentences of the paragraph?
I say that I think there's a distinction to be drawn between empirical data and, empirical evidence and hard facts or hard data. Because if you have an example, where an expert has produced a report and has relied on certain factual aspects, then to say that the expert report is not empirical, I say would not be appropriate. So you could have a situation, as indeed was the case in these proceedings, where you simply have economic theory and the Commission says not enough. But invariably one has experts relying on, drawing on the facts of a particular case to support their theory of the case. But if I was pushed to the extreme and said, if the question was put to me, is it possible that in a case pure economic theory could be enough, I would submit yes, because of Saltzgitter, which says the unfettered evaluation of evidence. Now, except in practice, that result would be unlikely, but my submission would be, as a matter of law, there is no category of evidence that is excluded as being potentially relevant. But then the next question is a separate one from the one we're considering, which is it enough to meet the standard? Our concern is with categories of evidence that may be relevant, not with who wins at the end of the day. Can I deal with the much flagged submissions about the Commission's practice in relation to the MIF? As I showed you in paragraph 6 of the Commission's exemption guidelines, The Commission said the standards set forth in the guidelines must be applied in light of the circumstances specific to each case. The Commission said that the guidelines exclude a mechanical application, and they said that the guidelines must be applied reasonably and flexibly. And it's precisely that approach that one sees the Commission itself adopt in relation to MIFs, because the Commission's consistent practice has been not to insist upon empirical analysis and data in respect of each aspect of Article 1013 in relation to the MIF. Now, I do need to show you a little bit of economics, but I want to make it absolutely clear that I'm not asking this court to make any decisions on detailed economic issues. This is simply for contextual purposes. I'm certainly not asking you, as AAM suggests, to decide that compliance with the MIT is sufficient to prove that the MIF rules under consideration are causative of net benefits to consumers under Article 1013. Our point is one of evidence. It's the law of evidence. I'm not asking for any rulings on economic issues. In around 2008, two eminent economists, Roche and Tirole, published a paper addressing MIFs. And if I can briefly show you that paper, it's at Appendix 1D, MS 7303. It seems that this paper has been published multiple times. I think everyone accepts it was first published around 2008. You see this version is actually dated at the bottom, June 2011, but there's no difference as far as we're aware in the context. So this is to be read as the Roche and Tirole 2008 paper.
It's just the merchant indifference.
It is the merchant indifference test, it is indeed. Introduction. In payment card systems such as Visa or MasterCard, the interchange fee paid by the merchant's bank, the acquirer, to the cardholder's bank, the issuer, allocates the total cost of the payment service between the two users, cardholder and merchant. In several regions of the world, competition authorities, banking regulators, and courts of justice have recently considered or even implemented regulatory caps on interchange fees that are based on issuers' costs. The premise for these regulatory caps is that unregulated interchange fees are set at unacceptably high levels. Merchants, the argument goes, accept to pay the resulting high merchant discount because they are concerned that turning down cards would impair their ability to attract customers. That is, cards are must-take cards, in the citation of Vickers 2005. And then over the page, however, there's no logical connection between this must-take cards argument and the issuer's cost benchmark used by regulators. So issuer's cost is a different way of assessing appropriate level of MIF. The main objectives of this paper are to analyse the validity of the argument and to drive policy implications for possible regulatory intervention. To this purpose, the paper develops a model of the payment card industry that is sufficiently rich to account for the complex effects of interchange fees on volumes of card payments, banks' profits, consumer welfare, and retail profits and prices, yet simple enough to assess their regulation. First, the paper validates the must-take cards argument by showing that retailers may be willing to accept cards even if the fee they have to pay exceeds their convenience benefit for card payments. This is because accepting cards increases the retailer's quality of service by offering to his customers an additional payment option. And then skipping to the next paragraph. Second, the paper provides an alternative benchmark for regulatory intervention. This benchmark is not based on issuers' costs, but on the retailer's avoided cost when a cash or cheque payment is replaced by a card payment. The empirical counterpart of this benchmark, which we call the tourist's test, gives some operational content to the notion of must-take card. Would the merchant want to refuse a card payment when a non-repeat customer with enough cash in her pocket is about to pay at the cash register? Put differently, the merchant discount passes the tourist test if and only if accepting the card does not increase the merchant's operating costs. So the essence of the tourist tests is a comparison of the costs of accepting a payment in cash with the cost of accepting a payment by card. And generally speaking, as we saw from the evidence in these cases, it is cheaper for merchants to accept payment by cards than by cash. Because when you accept cash, you have more staff, you have the handling issues, you have the banking issues, etc. But the essence of the test is a comparison, costs of accepting cash, costs of accepting cards. If we can turn to MS 7308. You see the heading, the avoided cost or tourist test. And if I can pick it up at the second paragraph. Let us introduce the avoided cost test or tourist test. Suppose the buyer in question is a tourist who will never patronize the store again in the future and shows up at the cash register with ostensibly enough cash to pay the wares. The merchant discount passes the tourist test if the retailer is willing to allow this consumer to pay by card, or equivalently, if accepting the card does not increase the retailer's operating costs. And then under the definition, the attraction of the tourist test resides in the fact that the merchant pays no more than his convenience benefit from card payments. Capping the merchant discount at the merchant's convenience benefit prevents card payment systems from exploiting the internalization effect to force merchants to accept card payments that they do not want. Perhaps more importantly, from an economic point of view, the absence of overpayment by the merchant suggests that the cardholder is not over-incentivized to use the card. So that's the basis of this merchant indifference test. That's all, my submission, that's all I need for these purposes to show you what the essence of it is. It's also fair to point out that the test has been developed in separate papers actually by Roche and Tirol subsequently. So Tirol, for example, published an article which took account of the basic test but developed it for credit cards, because the added advantage of credit card is that the cardholder has the benefit of credit, which can lead to benefits for a merchant which are not captured by the basic tourist test. But we don't need to get into the detail of that, just to let you know that there have been developments since. The merchant indifference test, or MIT, or tourist test, those three names are used interchangeably, has been used on a number of occasions by the Commission to assess the acceptable level of MIFs. And we've set out in some detail those examples at paragraphs 97 to 103 of our written case in the appeal. I'm not going to turn that up. I'll just again give you the reference. Core Bundle 1, MS, page 4948. And I'm not going to take you through all those examples now, because I don't need to make good the point that the general approach that has been adopted by the Commission, certainly subsequent to its 2007 decision, is to apply the merchant indifference test in order to assess compatibility with Article 1013. The first example I would like to take you to is a 2014 Commission decision accepting commitments by Visa in relation to certain credit card MIFs. We find that in Appendix 1D, MS, page 7210. You see European Commission decision. The date is the 26th of February 2014, so 7 years after the MasterCard decision, addressed to Visa Europe. Now, let me make it quite clear at the start that this was a commitments decision in which the Commission decided to terminate an investigation under Article 101 in return for commitments by Visa to limit the level of certain credit card MIFs. So it is not a final infringement decision. It's not a final decision whether Article 1013 was satisfied by those commitments or not. It's not a final decision in that sense. But clearly the Commission relied on the commitments and as a result stopped its investigation. But the important point is the way in which the Commission itself explains the significance of the merchant indifference test when applying Article 1013. If we can pick it up, please, at page MS 7232. Recital 104. When analysing MIF levels, the MIT, a methodology originally developed in economic literature, and you'll see the reference in footnote 24 to the Roche and Tirol article, and then further developed by the Commission to assess efficient interchange fees, was applied. This methodology is used by the Commission as a benchmark or proxy for assessing compliance with Article 1013 of the treaty as a methodology that is economically robust enough to ensure that merchants benefit from card acceptance. It's quite clear that Recital 104 is stating that the Commission considers the MIT to be an appropriate benchmark or proxy for applying Article 1013, and it's not simply in the context of commitment decisions that it's relevant, because you see both the Commission and the retailers trying to say, well, this is just a commitments decision, but the language is quite clear. Take what the Commission says in a published decision at face value. Recital 106 just reiterates what the MIT is. Transactional benefits of card payments compared to an alternative payment instrument have to be quantified and measured in monetary terms. So you see that sort of reference. My Lord Reid was putting the point to me from the 2007 decision. But that is met by the MIT. The MIT-compliant MSC should not exceed the level of the measured transactional benefits. In order to compute the MIF compliant with the MIT, the average acquirer margin and the scheme fees paid by the acquirer are deducted from the MIT-compliant MSC. 107. Economic theory indicates, the Commission relies on economic theory, indicates that the MIFs which comply with the MIT should allow merchants and their customers to benefit from increased card use. To the extent that the MIFs are passed on to the cardholders by the issuers, so issuer pass on, they ensure that cardholders make efficient choices with respect to payment instruments. So the MIT tells you the issuer pass-through answer. Furthermore, MIFs that comply with the MIT allow cardholders, when choosing their payment instrument, to internalise the transactional benefit for merchants. And then 108, by ensuring that merchants taken together are indifferent between accepting and handling card payments and other means of payments, especially cash, such a MIF creates a level playing field for competition between alternative payment instruments, while it prevents card schemes from exploiting the reluctance of merchants to turn down card payments, as they are afraid that their competitors would steal their customers if they refuse to accept card payments. In this context, a MIF that is above the MIT-compliant level would not appear to create benefits for merchants and consumers that would outweigh the possibly anti-competitive object. So a MIF above the MIT wouldn't satisfy the balance, restriction on competition benefits, but a MIF at or below the MIT does. That's what they're using the MIT for. And recital 109, that amount, the MIT-compliant level, was calculated by comparing the merchant's costs of accepting payments in cash to those of accepting payments made by payment card. And the source of the merchant's costs was 4 studies published by the central banks of the Netherlands, Belgium, and Sweden. So just to sum up under this approach, benchmarks or proxies relying on economic theory are considered to be appropriate to assess MIF compliance with the Article 1013 exemption conditions. The MIT, as applied by the Commission, is based on data about the costs incurred by merchants in processing payments. It does not require the provision of evidence from issuers. For example, about the extent to which the MIF is passed through to them, by them, to cardholders in order to encourage card use. And equally, the application of the MIT theory does not involve any special adjustment to take account of always card transactions based on empirical data about the extent of such transactions. Always card transactions comes in purely through the expert report of Mr. Dryden. You don't find it in the literature, you don't find it in the Commission decisions, this need for empirical data on always card transactions. And the evidence of Mr. Dryden was before Mr. Justice Popplewell, and Mr. Justice Popplewell preferred the evidence of Dr. Niels. That's not an issue for this court. Now, this approach was applied also in an earlier commitments decision by the Commission, 2010, when it accepted undertakings from Visa in relation to certain debit card MIFs, and that's one of the examples in our written submissions, so I'm not going to go through that in detail. But the same analysis was used for debit cards. The MIT was used as a proxy to check whether the levels in the undertakings offered by Visa were acceptable under Article 1013. And this approach was also applied as recently as 2019, after the Court of Appeal's judgment. And one sees that in the Commission decision of 29th of April 2019. We need to go to the Appellants Additional Documents Bundle. That's tab 7, it's MS, page 7522. So you'll see European Commission, Visa MIF, Article 9 Regulation EC1 of 2003. It's another commitments decision. The date, 29th of April 2019. It's up at Recital 1, or MS 7525. Subject matter. This decision is addressed to Visa and concerns Visa's rules on interregional multilateral interchange fees. So this is a different type of MIF again. Then MS 7534. Recital 47, you'll see the heading Proposed Commitments. The key elements of the commitments offered by Visa are set out in the recitals below, and then at 48, you'll see the levels that are offered in relation to interregional MIFs. Then MS, page 7538. Recital 71, you see the heading MIF caps for card present and card not present transactions. So it's looking again at a particular type of MIF. When analysing MIF levels, regard should be had to the merchant indifference test, MIT, a methodology originally developed in economic literature. Again, the footnote reference to Rocher and Tirol. And then further developed by the Commission to assess efficient interchange fees. The Commission uses this methodology as a benchmark or proxy for assessing compliance to Article 1013 of the treaty so as to ensure that merchants benefit from card acceptance. So as to ensure that merchants benefit from card acceptance. Again, the statement is not limited to commitments decision, it's put as a general approach. This approach is reflected in the Commission's previous commitment decisions, footnote 35, and you have a reference to the two Visa commitments decisions I've referred you to, the debit card one, 2010, and the credit card one, 2014, in determining ranges of MIFs that would likely benefit merchants. Then recital 74, economic theory indicates that the MIFs which comply with the MIT should allow merchants and their customers to benefit from increased card use and to increase the acquirer's scope for reducing and differentiating their MSCs. Furthermore, to the extent that the MIFs are passed on to the cardholders by their issuers, they also ensure that cardholders are properly guided in their decision to choose the most efficient payment instruments. And then over the page, MS 7539, recital 76. In order to perform the MIT, taking into account the specificities of interregional transactions, the Commission conducted a market investigation requesting data from Visa, MasterCard, certain competitors and merchants. You'll see that issuers are absent from that inquiry. 77. The MIT-compliant MIF caps were calculated by comparing the merchant's costs of accepting payments made by debit and credit cards to those of accepting payments made with alternative means of payment. 78. In order to compute the merchant's costs for credit and debit cards and the relevant alternative means of payment for CP and CNP interregional transactions, the Commission has relied on the merchant's cost data collected in the context of the cost of cash and card study. And you'll see footnote 37 is a reference to survey of merchants' costs of processing cash and card payments, final results March 2015, and I'm going to show you that in a minute. And further complemented by data specific to interregional transactions gathered from the respondents to the market investigation. So in our submission, it's quite clear from the Commission's consistent practice since its 2007 decision that it has relied on the MIT as a proxy to show compliance with Article 1013 of certain MIF levels. And certainly what one also sees from the Commission's practice is it's inconsistent with and shows the problem with the Court of Appeal's finding that there is a legal requirement that in order to show that Article 1013 is satisfied, undertakings are required to produce empirical data on all or any aspects of Article 1013, including, for example, issuer pass-through and always card transactions, because the Commission doesn't require it. Now,
just on that, in recital 76, it says the Commission conducted a market investigation and requested data. So I mean, why is that not an empirical testing of what the parameters of the theory might suggest?
Well, that's the point I'm going to come on to show you that there was empirical data in this case. So there's two separate questions. There's the legal issue, which is empirical data required as a matter of law for all or any aspect of Article 1013? And you have my submission on that. And then there's a separate question, which is, in this case, did MasterCard and Visa rely on empirical data? Which is actually less relevant to the issue before you, but it's obviously an important part of the context.
But there was empirical data in this study you're showing us, the 2019 report. There was empirical data relating to merchants' costs.
Correct.
Yes.
That's right. And indeed, there was data on merchants' costs. The same data, because footnote 37 of this document refers to the Commission's 2015 survey of merchants' costs.
Yes.
And that's precisely the evidence that MasterCard and Visa relied upon before Mr. Justice Popwell and Mr. Justice Phillips.
Using the same data was before
Absolutely.
the English judges.
Absolutely, yes. The expert analysis of our experts, the Visa and MasterCard ones, was based on this survey. And it's not the case that we simply took the basic MIF way back in 2008 and plugged stuff in. I want to make it absolutely clear, the experts all developed the analysis of the MIT in light of the data and the circumstances of this case, and then there was a dispute between them. So again, I make it absolutely clear, I'm not asking this court to say, yes, if you do a simple MIT to set out Russian material, that's the answer. That's not what we're asking this court to do. So MasterCard and indeed Visa didn't rely on economic theory alone at trial. We relied on data produced by the Commission on the transactional savings to merchants of accepting cards. We need to go back to Appendix 1D, MS, page 7351. So you see, this is a European Commission document. You see the flag and the heading top
Sorry,
centre.
we're at page 7?
7351.
7351, thank you.
Survey on merchants' cost of processing cash and card payments. Final results March 2015. This is the document we saw referred to in footnote 37 of the previous Commission decision. If we can turn over to MS 7352, Executive Summary and Conclusions. The Merchant Indifference Test, MIT, is a test that was developed in the academic literature. It aims at calculating a level of interchange fee that makes the merchants on average indifferent between a transaction by cash or by card. In unilateral undertakings and commitments offered in competition enforcement cases regarding multilateral interchange fees, MIFs, the MIT has been applied as a benchmark for assessing efficiency justifications of MIFs brought forward by payment card schemes under Article 1013 TFEU. However, public information on the costs of payments is scarce. So remember the Visa commitment decisions, the first two I showed you were 2010, 2014, and this is a 2015 document. The present study, carried out by DG Competition, has the objective of contributing to filling this informational gap for ongoing and possible future competition enforcement cases. Thus, the aim of this study is to measure merchants' costs of processing payments in cash and card in a complete and precise manner for the purpose of applying the MIT in the framework of efficiency justifications brought forward by payment card schemes under Article 1013 TFEU. And effectively, MasterCard and Visa accepted that proposal by the Commission that this is how it should be done. Paragraph 3. The study is also intended to play a role in the context of specific competition law enforcement cases as a point of reference in the analysis of facts and arguments based on Article 1013 TFEU. And then MS 2164, paragraph 62.
MS 7354.
I'm so sorry, I've given you the internal one. Thank you. 7354. However, it should be clear that the market effects of MIFs are of a degree of complexity that makes it impossible to determine the exact optimal level of a MIF. A credible efficiency defence of MIFs under Article 1013 TFEU will therefore by necessity relate to some benchmark which has desirable competitive characteristics, but will nonetheless be unlikely to fit all conceivable market configurations. And that echoes the exchange that Lord Reid had with me earlier about impossibility, etc. The Commission itself has recognised the impossibility of saying you must produce empirical data on every aspect of the 4 criteria in order to satisfy 1013. Recognises expressly here, and that is why one sees the Commission consistently basing that analysis on the MIT on the basis of merchant costs. Now, you have been spared in the bundle I can't remember, 100-odd pages that follow this with all the detail of the findings, because this court doesn't need to go into that. But MasterCard and Visa relied on the data in this survey when presenting our own case on Article 1013. And our case was based on the MIT. It wasn't a simple application of it. But one might have thought we were doing exactly what the Commission had been doing and indeed was inviting undertakings to do through this survey. MasterCard did not rely purely on economic theory, as you might think from reading the Court of Appeal judgment. It relied on detailed and extensive empirical data produced by the Commission in this survey. So to conclude on this issue, the flaw in the Court of Appeal's findings was to find that there was a legal requirement to produce empirical data on every or any aspect of Article 1013. And in our submission, that was inconsistent with the EU law principle of the unfettered evaluation of evidence and it was also inconsistent with the English law approach to evidence. So for the two reasons, failure to respect the unfettered approach to evidence and applying essentially a heightened balance of probabilities test based on inherent improbability, the Court of Appeal committed 2 errors of law in its findings on the approach to evidence under Article 101.3. Unless the Court has further questions on that issue, I plan to move on to something probably slightly less esoteric, which is the broad acts principle. So this is what has been described as the fourth issue. If we go to the Statement of Fact and Issues, that's Core Bundle 1, tab 15. It's MS, page 4850. 66. You should pick it up at 4849. You'll see the heading, the issues. And then at the top of page 4850, sub 4, did the Court of Appeal find, and if so, did it err in law in finding, that a defendant has to prove the exact amount of loss mitigated in order to reduce damages? This fourth issue concerns the legal principles applicable to the quantification of loss, to the quantification of damages. The question for this court is whether the so-called broad acts principle can be relied on by a defendant in relation to the quantification of a claimant's damages. Let me begin with relevant EU law principles in relation to damages for breach of Article 101. If we can go to the Court of Appeal judgment, paragraph 322, that's Core 2 MS, page 5273. Paragraph 322. There was little dispute between counsel as to the applicable law. Paragraph 323. The concept of pass-on is well established in EU law. The starting point is that persons harmed by breach of EU competition law have a right to compensation in the domestic courts of EU member states under domestic laws and rules which comply with EU principles of equivalence and effectiveness. But such domestic laws and rules may prevent unjust enrichment from overcompensation, reference to Court of Justice judgment encouraging Korean, where an unlawful charge has been borne not by the direct purchaser, but by the customer of that purchaser, to whom the cost has been passed on. Repayment of the full amount of the unlawful charge to the direct purchaser would amount to paying the direct purchaser twice over, and it is for the domestic courts to decide whether that would in all the circumstances amount to unjust enrichment, and a reference to the Court of Justice judgment of San Giorgio. So just to unpack that a little bit. Under EU law, each person who suffers loss as a result of the breach of Article 101 has a right to damages. Any person who has caused loss by that breach has a right to damages. Now suppose a breach of Article 101 has resulted in a higher price being paid by a direct purchaser for a product than would otherwise have been the case. The difference between that higher unlawful price, because it's higher because of the cartel, and the lower lawful price is usually referred to as the overcharge. The direct purchaser will have a claim for damages, but only to the extent that it has borne the overcharge. Where a direct purchaser has passed on all or any part of an overcharge to its customers by way of higher prices, those customers, indirect purchasers, will have a claim for the loss suffered by them. It's just maybe a chain of causation. The direct purchaser may only claim damages for the loss actually suffered by it, not for the loss suffered by its customers. And as is explained in the cases, if it were otherwise, the direct purchaser would be overcompensated for loss it hasn't suffered, and the defendant would face the risk of paying for the same loss twice, because there would also be a claim from the indirect purchasers. So that's what underpins this notion of pass-on. And then there's a reference to a number of EU cases, many of which are referred to by Sainsbury's in its written case. I come back to them if necessary later, time permitting. You see 324, a reference to San Giorgio, to Comateb, to Weber's Wine World. In 325, a case called Lady and Kid. I'll come back to them if needs be. And then paragraph 327 of the Court of Appeal. Those principles of EU law are entirely consistent with common law principles of the assessment of damages and in particular mitigation. And then the court goes on to set out the common law principles of the assessment of damages. And it refers to three principles. First of all, paragraph 328, there's a reference to the well-known case of British Westinghouse. And the principle established by British Westinghouse is that, or one of the principles established is whenever a claimant has taken mitigating action, whether under a legal obligation to do so or not, and this has diminished the loss suffered, that diminution of loss must be taken into account when quantifying damages. It's a very well-known passage on the law of mitigation. Paragraph 329, referring to Lord Bridge in Hodgson and Trapp, damages are intended to be purely compensatory if, in consequence of the wrongful act, the claimant has enjoyed benefits to which it would not otherwise have been entitled, then prima facie the value of those benefits should be taken into account when quantifying damages. And the third principle, the more recent one, taken from Fulton Shipping, Lord Clark, sums received which have diminished the loss suffered are only to be taken into account if there is a sufficiently close causative link between the benefit and the wrong committed by the defendant. So those are the basic common law principles that the Court of Appeal said underpins the analysis of pass-on in cases such as those before you now. Now we turn to the exotically named broad axe principle. What is the broad axe principle? Can I show you, please, the judgment of Mr. Justice Lewison, as he then was, in a case called Devonish Nutrition against Sanofi Aventis. That's Additional Authorities, Volume 6, Tab 41, MS, page 2485. We don't need to go into the details. Suffice to say that this was another cartel, or this was a cartel case. Article 81 EC concerned a vitamins cartel, and this judgment concerned the issue of what remedies a claimant could claim. In addition to, for example, compensatory damages, could it claim an account of profits? And we're not concerned with that, but we are concerned with the reasoning in relation to the broad axe principle. If we can turn to page 2501. Paragraph 27. Watson Laidlaw and Hot, Castles and Williamson was a case of patent infringement. And the principal dispute about damages was whether the claimant was entitled to damages on infringing machines sold in Java. And I don't think we need to get into the details. If I pick it up just above G, the case before the House was a claim for damages, not an account of profits. Thus, the House was concerned with the claimant's loss rather than the defendant's gain. Lord Shaw said, "In the case of damages in general, there is one principle which does underlie the assessment. It is what may be called that of restoration. The idea is to restore the person who has sustained injury and loss to the condition in which he would have been had he not so sustained it. In the cases of financial loss, injury to trade and the like, caused either by breach of contract or by tort, the loss is capable of correct appreciation in stated figures. In a second class of cases, restoration being in point of fact difficult, as in the case of loss of reputation, or impossible, as in the case of loss of life, faculty, or limb, the task of restoration under the name of compensation calls into play inference, conjecture, and the like. And this is necessarily accompanied with those deficiencies which attach to the conversion into money of certain elements which are very real, which go to make up the happiness and usefulness of life, but which were never so converted or measured. The restoration by way of compensation is therefore accomplished to a large extent by the exercise of a sound imagination and the practice of the broad acts." So that's where one sees certainly an early iteration of the principle of the broad acts. Then going down to paragraph 29 of Mr. Justice Lewison's judgment, having set out a number of authorities, a number of points emerge out of these passages. First, the principle underlying the assessment of damages is that of restoration. Second, the restoration by way of compensation is often accomplished by sound imagination and a broad acts. This is true no less in claims for financial loss than in claims for personal injury. And he cites Blaney, which from memory I think was a judgment of the Court of Appeal, but he's bringing it up to date and saying it's not just in personal injury cases, etc. This can also be applied in claims for financial loss. Third, whatever method of assessment is followed, its object is the same, namely to get back to the position in which the victim would have been if the wrong had not occurred. And then paragraph 30. It is also the case that the common law has also taken a pragmatic view of the degree of certainty with which damages must be pleaded and proved. Ratcliffe and Evans was a case of a malicious falsehood. The plaintiff was an engineer and boiler maker. Again, I don't think we need to go into the details, but he cites from the judgment of Lord Justice Bowen, if I picked it up opposite D, Lord Justice Bowen said, "As much certainty and particularity must be insisted on, both in pleading and proof of damage, as is reasonable, having regard to the circumstances and to the nature of the acts themselves by which the damage is done. To insist upon less would be to relax old and intelligible principles. To insist upon more would be the vainest pedantry." And that analysis of the broad acts was followed by the Court of Appeal in Devonish. Again, the more detailed references are in our written case, and the principle indeed has been recognised and applied in a number of other competition cases. I think it's now fair to say that the concept of the broad acts is well established in competition damage cases. So the broad acts principle is therefore quite clearly relevant to the quantification of damages. It is intended to facilitate the application of the basic principle of restoration of the claimant. And the point was explained in our submission very clearly at paragraph 484, sub 3 of the Tribunal's judgment, which I'll simply read out, but I'll give you the reference. It's Core 2 MS, page 5582. But the way the Tribunal put it was this. "We agree with the submissions of MasterCard that the pass-on defence is no more than an aspect of the process of the assessment of damage. The pass-on quote-unquote defence is in reality not a defence at all. It simply reflects the need to ensure that a claimant is sufficiently compensated and not overcompensated by a defendant. The corollary is that the defendant is not forced to pay more than compensatory damages, when considering all of the potential claimants.
I think that point's made by Lord Haldane in the passage just cited from British Westinghouse.
I think that's right. It just seemed a pithy encapsulation, but there is higher authority to support the summary of the law, certainly. So it's important to filter out, to identify that there are a number of distinct questions at play here. First question is, has a claimant received a benefit, for example, by charging higher prices to its customers than would otherwise be the case? So first question, has there been a benefit? Second question, if so, is the benefit received by the claimant sufficiently closely connected to the wrong to be relevant to the quantification of damages? It's the Fulton shipping point, and it's a causation issue. And the third discrete question is, if the benefit is sufficiently closely connected, what is the quantification of that benefit? And the broad axe principle is relevant to the third question, i.e. quantification, but not the first two. Where a judge finds that a claimant has mitigated his loss in a way which is sufficiently closely connected to the wrong. So where the first two questions are answered yes, but it is difficult to put a precise figure on the extent of that mitigation, i.e. the third question, our submission is that the broad axe should be available to the judge to assess the extent of the mitigation in order to comply with the principle of restoration. That's what this fourth issue is about. It's not a perfect comparison, but a comparison of sorts can be made with the tort of breach of statutory duty, the ingredients of that tort, because the existence of loss is an essential ingredient of the tort of breach of statutory duty. But as a matter of law, in order for a claimant to establish a breach of statutory duty, it's sufficient for the claimant to establish that it has suffered some loss. It's not necessary for the claimant to prove the exact amount of that loss in order to make good the cause of action. And I simply give that example to further demonstrate that quantification of loss is a different question from the fact of loss and causation. There are three separate issues in play here. Can we go to the error that we say that the Court of Appeal made in addressing this issue? So Court of Appeal judgment, Core Bundle 2, MS, page 5275, paragraph 331F.
Again, please.
So it's page 5275, and
Got it.
You got it? Paragraph 331. Sorry, and I wanted to pick it up
At
opposite
letter
F.
Yes.
Sorry, exactly, sorry. So opposite F in the sideline. Fourthly, we do not accept Mr. Hoskin's submission that the broad axe principle of establishing recoverable loss, which we have discussed in the context of the first quantum issue, applies to the burden on MasterCard to establish the fact and amount of pass on by Sainsbury's. So they didn't accept MasterCard's submission that the broad axe was relevant to calculating the amount of pass on by Sainsbury's. The broad axe principle is applicable where the claimant has suffered loss as a result of the defendant's culpable conduct, but there is a lack of evidence as to the amount of such loss. There is no scope for the application of any such principle where the burden lies on the defendant to establish a pass-on of the unlawful overcharge in order to reduce the amount recoverable by the claimant. And again, so there was no doubt, it's accepted that the burden is on the person who alleges mitigation or pass on to prove it. In this case, MasterCard. So in other words, what the Court of Appeal found was that whilst the Broad Act's principle may be relied upon by a claimant, it can never be relied upon by a defendant in relation to the amount or quantification of a claimant's loss. And in our submission, that was an error of law. Turning to the...
Can I just ask?
Of course.
I just wonder if that's quite what they meant. They say there's no scope for the application of any such principle, a principle concerned with the quantification of damages, or you would say mitigation of damages, where the burden lies on the defendant to establish a pass-on. So they're talking about the discharge of a burden of proof to show that the loss actually suffered was less than is claimed. I mean, in other words, you have to prove, if you're asserting that the loss was passed on, then you have to prove that.
And we accept that the burden lies on the person alleging pass on to prove it. The passage in the Court of Appeal's judgment would be beyond reproach if it did not contain the two words "and amount." Because what one sees here is the Court of Appeal is dealing with two issues. One, the fact of pass on, which seems to be a reference essentially to the causation issue.
Yes.
But also then the amount. And the target of our appeal is simply the amount issue, so without blemish. So if, for example, my lord, this court were to rule that we have simply misunderstood what the Court of Appeal has said, and in fact the Broad Act's principle does apply to quantification, then this appeal disappears into thin air. But as I'm about to show you, not only do you have the wording in the Court of Appeal's judgment saying that the Broad Act doesn't apply to the amount, whilst I'm not sure there's an issue between ourselves and AAM on this, and I'll show you what they say in their written case, there certainly is an issue between us and Sainsbury's, because Sainsbury's is quite clear that in its submission, the Broad Act cannot be relied upon in relation to the quantification. So there is a live issue between the parties, regardless of what the Court of Appeals said. But our submission is it seems to be saying no Broad Acts for causation or quantification. Can we turn to the position of the retailers? First of all, AAM, I'd like to look at its written case, paragraph 162. The reference is Core Bundle 1, tab 20, MS 5134. Paragraph 162. So AM says, all that MasterCard now means, it seems, is that the overriding principle that the court should follow is that the claimant should be properly compensated for its loss. This entails that the court should not insist on unreasonable precision on the part of a claimant, nor on unreasonable precision on the part of a defendant who seeks to establish that the financial loss resulting from a breach of Article 101 should be discounted because all or part of it has been passed on in the form of higher prices. MasterCard is using the term Broad Acts to connote no insistence on unreasonable precision as regards the quantification of loss, which is not controversial. Now, Mr. Turner will obviously make his position clear, but it may well be there is no issue between ourselves and AAM on this point. But there is an issue, there clearly is an issue raised by Sainsbury's written case, because Sainsbury's argues that the Broad Acts is not a suitable tool to be employed by defendants in price fixing. certainly when discharging the burden of proving a causal link between the overcharge and higher downstream prices. But as I hope I've made clear, that's not our case. And it's not as clear, certainly, as the AAM submissions, whether Sainsbury's is saying the broad axe cannot be used in relation to quantification. But let me show you what Sainsbury's does say on this point. It's MS, page 5072. It's paragraph 204. No broad axe. The MasterCard argues for a rough estimation approach to the issue of pass-on, the broad axe, and seemingly spirits away the CGEU jurisprudence on the defence of pass-on and the CGEU's insistence on a strict interpretation of the defence. In Sainsbury's submission, the broad axe is not a suitable tool to be employed by defendants in price-fixing cases when discharging the burden of proving a causal link between the overcharge and higher downstream prices. So again, it just may be a misunderstanding. I have, I hope, made it clear that that's not our case. We're dealing with the third of the issues identified, broad axe in relation to quantification. We don't say that the broad axe is relevant to causation. It may well be when Mr. Brealey and Mr. Turner get on their feet, therefore it turns out there's actually common ground on this issue, but that would be common ground despite what the Court of Appeal has said in its judgment, that you can't use the broad axe in relation to the amount of pass-on. Can I turn then to MasterCard's submissions?
But you're working on the basis that you have proved a causal link between the prices that you charge and the existence of the myth.
Indeed, this question would only arise in that context. Now, in the Sainsbury's trial before the tribunal, we failed to do so. But the question is still live in the AAM case if it goes any further, and the question is live for Visa if its case proceeds to a damages trial. But absolutely, that's when it would arise, and not otherwise.
Oh, sorry, can I just make sure I've got that? A note of that. I appreciate this is all being recorded, but have I got that noted correctly? That you accept that you failed to prove a causal link in which proceedings?
In the Sainsbury's claim against MasterCard in the tribunal. Because that was the only one of the three cases before you that was a quantification trial.
Yeah.
The trial before Miss Justice Popplewell and the one before Miss Justice Phillips was purely on liability.
So you proved the causal link in the AAM proceedings?
It wasn't it didn't come up. It wasn't considered. Right. So AAM in front of Miss Justice Popplewell was purely liability, not damages, and likewise for Visa in front of Miss Justice Phillips.
So for AAM and Visa, this is a future matter.
That's right. That's right. But the point, obviously, is of general importance to the law of tort. It's clearly a generally important issue.
Because I thought there had been evidence, it must be the Sainsbury's case, that one passed on, to the effect that costs were passed on, but one couldn't work out a stream of costs attributable to the MIF, and therefore it wasn't clear that a causal link was demonstrated. Am I wrong about that?
You're absolutely right on that.
I'm right.
The finding of the tribunal on the evidence was that MasterCard had failed to establish a sufficiently direct causal link. So we didn't proceed to this third quantification question.
Thank you. Your answer makes...
So if you succeed in your arguments on broad axe, you can't reopen the Competition Appeal Tribunal ruling.
Not on that point, because we appealed it on a particular point in front of the Court of Appeal, and we failed on that. Okay. And we have not appealed that point to this court. So we're stuck with that come what may.
So this issue is purely future oriented. Is that right in relation to the AAM case and the Visa case?
Yes.
Right. Thank you.
I should perhaps mention that almost all of the broad axe authorities you've referred us to were discussed in One Stop and Morris Garner by this court. But from recollection, I don't think anything was said that differs from what's said in in the material you've taken us to, but you might just want to check
We've
that.
checked. So what was the
in
case? I'm
case.
sorry, my lord.
It's called one
step.
one step, and
One
I should remember.
Step.
One step and Morris Garner. It's a decision from 2018.
We'll do our homework. I'm sorry, we're all slightly blinkered here because it's so well established in the competition
Yes.
sphere that we've gone to those authorities.
Or possibly 2017.
Thank you.
It's a case about user damages and what's it called? Negotiating damages.
So MasterCard submissions on this issue. Our first point is this. The broad axe is intended to facilitate the application of the compensatory or restorative principle. That is to ensure that a claimant recovers damages in respect of the loss actually suffered, but no more than that. Given that the quantification of loss must take account of relevant acts of mitigation, I use relevant as a shorthand for sufficiently causally connected, in order to achieve compensation, there is no good reason of law, logic, or principle why the broad axe should not be wielded in order to achieve the aim of compensation or restoration, and no more than that. Where a judge finds that a claimant has mitigated his loss in some way, and that there is a sufficiently direct causal connection, but it is difficult to put a precise figure on the extent of that mitigation, applying the broad axe to the issue of quantification ensures compliance with the principle of restoration. So in other words, if the answers to the first two questions, is there a benefit, is yes, and the second question, is it sufficiently directly connected to be relevant to quantification, is yes. When you come to the third question of quantification, there is no legal fairness principle reason why you shouldn't use the broad axe in that context.
I mean, might it be said that when you're looking at a claimant who is the innocent party on the receiving end of a wrong by the defendant, the court might be willing to be a bit more generous in its approach to assessment of loss to, in effect, make sure that its interests are protected as the innocent party, and perhaps not necessarily that factor doesn't necessarily apply across to a defendant that's trying to establish as a wrongdoer that some limiting principle applies.
Well, I'm sure that is the basis upon which one could justify the approach of the Court of Appeal, and I imagine that is, reading between the lines, what the Court of Appeal thought. It seems to come out of the passage I took you to. The problem with that, as a basis for this finding of law, is that, of course, when one goes to the absolutely classic cases on assessing damages, so, for example, British Westinghouse, etc., one sees no hint of one must favour the claimant over the defendant. In all the authorities dealing with mitigation, it's quite clear that the overriding principle is to ensure compensation and not overcompensation. So my submission, if one were to introduce, in this case, at this stage, to the law of tort, that sort of principle that somehow one has to look more favourably on the claimant rather than the defendant, one would be putting a principle into that law, which one does not see in any of the cases to date. It would be quite a leap in the development of the law, and our submission one that's not justified, given that the law is well established. For example, the aim of damages is compensation. One must take account of mitigating acts, even if the claimant wasn't legally obliged to adopt them, etc. The whole stream of this case law for a very long time is a neutrality between claimant and defendant, and not some sort of apportionment of blame just because it happens to be the defendant. The approach is neutral.
Yeah.
My recollection is in the one-step case. There was a distinction made about of some authorities where the court, where where one of the parties could have led more detailed evidence but had failed to do so. And in that situation, the court would err, as it were, in favour of that party's adversary.
I would say that's a different, it's one we touched on when we dealt with the law of evidence, because that would be an assumption against a party who had failed to produce evidence that was readily available, rather than an application of the Broad Acts principle or the principle of competence.
Right, the classic, exactly, it's a different principle. Yeah.
My dear Mr. Hoskins, that there's some authority in tort, particularly in cases of conversion, where assumptions are made against a wrongdoer. Armory and de la Mairie is the case that's the case about the jewel, where it should be assumed against the converter that it was of the finest water.
Yes.
But that may be because it was the wrongdoing of the defendant which had prevented the proof of the quality of the diamond.
That's certainly the way I would put it. It's a similar point to the point that was put to me by Lord Reid, in a sense, where it's due to the defendant's fault that a particular point can't be proved, then it may be appropriate to assume against the defendant. But my submission is, on all these absolutely textbook authorities, it's quite clear, whichever issue one is looking at, the principle is one of neutrality, because one is looking at achieving compensation, not overcompensation.
Your principle applies to contract as well as tort, does it?
Not necessarily.
Okay, why not?
Well, I say not necessarily because one sees cases in which the principle has been read across into both. But my submission only has to go as far as we are dealing with a tort here. And in relation to those principles, that's a submission that would be objective. I don't want to go into an area in which I'm having to say what the principle in relation to contract would be, unless you need to push me, because that flags out the issue. But my submission today before this court is limited to the law of tort.
And so it struck me when you were referring to the CGEU Italian case about unjust enrichment, where tax had been overpaid. I'm afraid that, yes, it's a phrase that ought to be engraved in my heart. I mean, that is to do with unjust enrichment, where different issues would arise about passing on, for example, as a defence. And this court has, in fact, considered that to some extent and not been very sympathetic to a passing on defence. But we can put that to one side here, can't we?
We do, absolutely. There is a whole stream of case law on unjust enrichment in the context of the law of restitution. And it's unfortunate the phrase unjust enrichment has been used by the Court of Justice without an eye to the distinction in English law, certainly between restitution and tort law. So that's why I've used the phrases like overcompensation, benefit, and not unjust enrichment. We're certainly not in the restitution field.
I've been given a note, incidentally. One step is 2018 UKSC 20 and 2019 appeal cases 649.
Thank you very much. I'm sure we'll all have a close look at that. The second submission I wish to make on this is that a claimant has no right to be overcompensated under English or EU law. This is a related sort of flip side point. In circumstances where a defendant has established that a claimant has diminished its loss in some legally relevant way, in our submission it would lead to overcompensation for the law to refuse to take account of that diminution in loss because of insistence that a defendant should be able to prove the amount of that loss with precision. And here I pray and aid the colourful language of Lord Justice Bowen in Ratcliffe and Evans that I showed you. Only as much certainty and particularity is insisted on in proof of damage as is reasonable, having regard to the circumstances and to the nature of the acts by which the damage is done. As a statement of principle, that is capable, and we say should apply equally to claimants and defendants. In the words of Lord Justice Bowen, to insist upon more would be the vainest pedantry. The third point relates to double recovery, and there's a certain extent to which these are all related. If a defendant were not entitled to rely on the Broad Acts, this would often create a very real risk of double recovery, because in a situation in which claims were brought both by direct and indirect purchasers, or indeed could in principle be brought by direct and indirect purchasers, if the direct purchaser action came to trial first and no deduction for pass-on were made, solely because of differences of quantification, then a defendant could be required to pay damages in respect of the same loss twice over to both the direct and indirect purchasers, simply because it couldn't wield the Broad Acts in relation to the first action which came to court. And that danger might well apply equally if the indirect purchaser actions came to court first as well.
I suppose you could say that they might all be tried at the same time.
Well, that would obviously solve the problem, but that's...
Well, but except that, yes, the indirect purchaser, both sets of claimants would presumably be trying to rely on the Broad Acts principle. So correct. It might be said to be a bit odd if they both can rely on that, but the scheme can't rely on the Broad Acts to partition its liability.
That's correct. I see it's 1 o'clock.
Yes, that's a convenient moment. Then we'll adjourn now and resume at 2 o'clock.